welcome to Just Talk Funerals with me, Jason Threadgold.
And me, Nicola Threadgold.
Just Talk Funerals is all about the funeral industry, the people that work alongside us, and an insight into what we do.
We will have some special guests along the way, sharing their experiences and how their professions overlap with what we do.
So get yourselves comfy, grab yourselves a cuppa, and let's get into today's episode of
Just Talk Funerals. And hello and welcome to another episode of Just Talk Funerals. And today we're going to be looking at the legal side of death. And with us we've got a special guest with myself and Jason, and that is Laura King. Welcome, Laura.
Hello.
So first of all, do you want to tell us a little bit about what you do?
So my name's Laura and I work at Mason Bagot and Garton Solicitors. I am what they call a private client advisor, which is in a fee-earning role in relation to wills, probates, powers of attorney and court of protection work.
Excellent. And how long have you worked there, Laura?
23 years.
So very experienced then, I would say.
Very, yes.
Yeah, I mean, obviously we have dealings with you, don't we? And you give us quite a lot of advice, and you know, it's always interesting to see from a sort of the legal side and that perspective of how things work. So we've had a good relationship for quite a long relationship for quite a long time, haven't we?
We have, yeah. Excellent.
Okay, so let's get straight into some of the questions we've got for you, Laura. So in terms of the funeral arrangements, you know, is there anybody, you know, we get this question asked quite a lot, but, you know, legally, is there somebody that should be the person that has the legal right to arrange a funeral, or can it be anybody?
So there is, and legally it should be your executor if you've made a will.
Okay.
So when you choose to make a will, you can choose who you want as your executors, and that can be a family member, a friend, a professional person or similar.
Yeah.
And in general terms, it should be that person that you're taking your instructions from.
Okay.
There are occasions when you won't have that because people haven't made a will.
Yeah.
And there are occasions where family want to do it, and some people will try to override other people, and that can be family members and professionals.
Yeah, okay. And I think it is worth saying, you know, we do see that occasionally, don't we, where, you know, different parts of the family have different ideas or feel that authority-wise, you know, they should be the one.
Not everybody gets on, not everybody's got the same ideas or wishes, or, you know, some people think they know what the mum or the dad or the granny wanted, whereas other people don't, but have still got their preference or their choice.
Yeah, okay. And so what happens if, you know, families do disagree? I mean, there's been times where, you know, a funeral director has gone to arrange a funeral and we've had to come away from that initial arranging because they just couldn't agree.
Yeah.
But, you know, what if it goes deeper than that and, you know, they have to, or we have to sort of look at what the law is, you know, how does that work?
So I think, again, if you can't work it out between everybody, you know, and if you can't find that line where there's going to be the balance of they're going to agree with them, or, you know, you can have that person's decisions in one respect and that person's decisions in another, you have to go a bit further up, and if they've got a will, then see who the executor is, and if it's somebody different, take their view, because it would be independent. And if, again, that fell to somebody like us as professions, then we would make those decisions for them.
Yeah, okay. And when we talk about funeral arrangements as well, you know, we're not just talking about somebody that has maybe passed away at that point. When we talk about funeral plans, prepaid funerals, you know, are there sort of protections around that in terms of the legalities as well?
Yeah, so if you've put a funeral plan in place, setting out what your wishes are, particularly the paid plan, then you as funeral director should follow those wishes as far as you're able to, unless something's changed. That means you can't physically put that wish in place. There's things that family can choose as extras, and obviously if the deceased has got money to cover the cost of it, within reason you can have whatever you want as an added extra, but you should still follow that person's wishes.
Yeah, okay, excellent. Okay.
So you've touched on wills there. For you, can you sort of explain to people the importance of having a will, really?
So the importance of a will means that you can make your own decisions and set your own wishes. That might be different from the law. So if you've not got a will, the law states who benefits and how.
Yeah.
Not everybody gets on with a family, not everybody wants those next in line to benefit. Not everybody's got immediate family members and might want it to go somewhere else as opposed to distant relatives that they've, never even met or are aware of. So by making a will, you're deciding what can happen to your estate. You're, setting out your wishes. You're putting who benefits and how. You can put funeral wishes and similar in there. You can do letters of wishes to support your will, setting out certain things that you might want to happen where possible, but not necessarily legal wishes. So there's no law that states you have to have a will, but it's very important if you've got certain wishes that you put one in place, because if you don't, then obviously the law states what will happen.
Yeah.
So the terminology we use is intestate.
Yes.
So if you pass away intestate, how complicated is it for you when you're administering somebody's estate?
It depends on your family lines. So obviously, in the situation where you've got a Mr. and Mrs., you've got children, you've got grandchildren, so the usual family status, what follows naturally through those immediate lines, is quite straightforward. When you're looking at people who have never married, haven't had children, so therefore haven't got grandchildren, it's more complicated because you then have to backtrack up the family tree to then come down it to work out who should benefit, who's alive, if those people were alive in the sense of the level that you're at. So say we're at brothers and sisters and you've had brothers and sisters but they've passed away, you're then looking at the next level because those brothers and sisters naturally would have benefited, so it would then pass to their children. So it can get quite complicated when you're looking at especially the older person who've got the bigger family and you're going down both the maternal and the paternal side to work out how many children and how many children each side had for brothers and sisters, aunts and uncles and similar. It can get quite complicated and quite messy.
Okay. So if you do have a will and you appoint executors, whether they be individuals or a solicitor firm, what's the responsibility of that executor? What do they have to physically do?
It's quite a lot. It's only as complicated as you make it in one sense, but that also depends on the person because not everybody's as capable as others. But an executor's responsibility is to find out what the person had, find out the value of everything that they had, and then find out the value of any bills, debts and responsibilities, make sure that that person's got enough assets to cover the debts and the responsibilities before you take it any further as an executor and say, yes, I'm going to do this job. Yeah. Because obviously the risk is then on you in some respects if that person has got debt or if their estate is insolvent. So once you've done all of that, you would then look to the next stage to say, okay, as an executor, I feel comfortable with this. I can manage those assets. I've got enough in the estate to cover the bills and similar. Yeah. And then once you've administered, you would then obviously look to people who benefit under the will down the line. So it's quite a lengthy job because obviously you can't do it all in 5 minutes as such. It takes months. People think they can do it in weeks, but it doesn't. It takes months.
So say, for instance, you have an executor that's been appointed by somebody and they were unaware that they'd been appointed.
Yep.
Can they then stand back and say, I don't want to take on that responsibility?
Yes. Yeah, so an executor has 3 options when it first comes into force. So one is, yes, I'll do it, which you would do all of what we've just explained first before you then say, yeah, okay, I'm happy with this, I can do this. One is to say, no, I don't want to, and have what we call power reserved, and that might just be based on your circumstances. So if there's more than one executor appointed, any number of those executors can have power reserved, which is like taking a back seat. So if your own personal circumstances meant that you wasn't in a position at this time to undertake that estate, you can have power reserved. And then down the line, if, say, the named executor was to pass away or similar and the estate wasn't finished, that person can step back up. Or alternatively, you can renounce probate and move away from it completely if, in particular, it was insolvent and you didn't want to do it or there was too much risk on you.
Okay. So we hear this word probate used a lot. Can you explain to all the listeners and viewers what probate is and when you would need to go for probate?
So probate is the legal document that you have to get as an executor. to say that you are now taking on this estate and you've then got the legal power to close bank accounts, sell property and similar. It's actually called a grant of probate, and in an intestate situation it's called a grant of letters of administration. They're very similar, but the main difference is obviously your probate has the will attached, whereas the grant of letters of administration doesn't. If an estate is worth more than £5,000, which in general terms most are, you are supposed to apply for it. You make your application to the probate registry, and it's on the basis of all that earlier information you've collated to ascertain whether there's assets, whether there's liabilities, etc. Those figures help you calculate the gross and net values of the estate for probate and also for tax purposes. Once the probate is issued, you would then use that document as the executor to physically close the bank accounts, to sell the property, to transfer shares and anything else that you might need to administer.
What do you see as common problems or delays when you're applying for probate?
So the biggest delay we have at the moment is the probate registry. So following on from everything with COVID, the rules and the regulations changed slightly. They closed all the smaller registries, meaning there's less people dealing with the probate application, and they changed everything to an online portal. So there's odd occasions where you can still apply on paper because you have to, but most of your applications are done online. You still have to send all your supporting documents thereafter, so your will, your legal statement, etc. And you have to wait for your online application and your documents to meet at the other end before they'll then look at your application. They then also, because there was a build-up of applications and a delay with getting them processed, they currently have a 16-week wait.
Wow.
So that's what they tell you, and that's what we have to tell you. They are coming through quicker, but there's no way of knowing or guaranteeing which one will come back quicker than any of the others, and sometimes you're getting the more complicated applications back quicker than the straightforward ones. But it's just pot luck at the other end.
So if somebody was administering somebody's estate and they used a solicitor to help with that, what would be the typical costs that they think they would incur?
It varies, and it varies based on the amount of work that's going to be necessary, which obviously every estate is different. Some people have one bank account, some people have several, some people have property, some people don't. We have a set fee of £700 plus VAT for applying for the grant of probate. And then on top of that you have your court fees, which is currently £300, and that's across the board. If we were dealing with an estate, you're always going to pay a minimum of that if we've got to get you that grant of probate, because we've got to do the same amount of work to get it, whether we do the grant only for you and then you go away and do the rest, or whether we do all of it. So you're always going to be looking at about 700. When you've got bank accounts to close, shares to deal with, everything takes time, and different institutions take different lengths of time to process things. But I would say generally you're looking anywhere from £1,000 to £2,500 just to deal with an average estate, because you just don't know what's going to happen. How long it's going to take, if you're going to hit any difficulties throughout the process. You know, if you're going to get family that aren't happy that crop up midway through. So you take your instructions, you think, this is a relatively straightforward estate, I can deal with this in no time. And then something just throws a spanner in the works.
It sounds very interesting.
It is interesting because everybody's
different.
So you'll see similar similarities in the sense of interesting, because you see a variety of different people with different situations. So it's certainly interesting.
Before we move on, I've just got a question. If we can just go back to the will side of things, you know, when we look at meeting with families to talk about having a funeral plan, there are often conversations around, do you have a will? And, you know, we're still in this day and age, we do get a lot of people that still don't have a will. Do you think that's still a big number nationally? We get a lot of people in for other things, but then when you mention the will, they're like, I've not got one. And you get a lot of people in, even when they come for will appointments. So like, say yourselves came a Mr. and Mrs, you get one who's here because they want to do it, and one that doesn't.
And one who's like, whatever she said, you know, go with the flow. because they're not that fussed about
Yeah.
sorting it out, or they don't want anything too complicated, or they don't want to think about the fact that they're going to pass away and then the will's going to come into force. I mean, like I say, there's no law that says you have to have a will.
No.
But it is definitely
Protecting
better.
your own,
yeah,
isn't
it's
it?
better for yourself
Yeah.
because you can give those instructions and make those wishes,
Yeah.
and let everybody know what you want. But it also is better for not just people like ourselves, but whoever is your executor, because it makes their life easier.
Yeah.
There's so much more you can do initially when someone's passed away if you are the executor and you've got a will to prove that,
Yeah.
than if it's intestacy and you're having to prove you're the next in line,
Yeah.
and the person that should be dealing with it, because until that grant's issued under an intestacy, you've got no power or no authority or anything.
Okay. Yeah, really interesting, that one. Okay, let's talk about debts and assets. So, are family members personally responsible for debts?
They are once a grant has been issued. So if you take the grant, so you're appointed,
Yeah.
you say, yeah, I'm not bothered about what the situation is, I can do that. You take the grant. Once the grant is in your name, you have the responsibility to administer that estate. And if you've not got the funds in the estate, there is a chance that they could then look to you
Yeah.
as the person named for those debts, which is why generally we wouldn't advise you take it on if you've got all that information to show otherwise.
Yeah, definitely. So can that surprise some families then that don't realise and then...
Yeah, a lot of people think you've died, so the debt's died and the debt's gone away and that's it. And when you explain to them, we need to know what assets there are, and like when they say, well, they had a house, okay, well, we'll sell that and we'll use that money to cover all those credit cards and other things. Oh no, you can't do that. It's like, well, yeah, that's what you've got to do, because the debts don't just, with or without a will, the debts don't just disappear. A creditor can chase for up to 2-3 years afterwards if they think there's a chance that they're going to get some money from somewhere. And even when we've taken on an estate where we've written on your behalf and we've written to everybody and said, look, this person's passed away, there's no money, there's no chance of you getting any, or there's a very little bit that we're going to have to split across people, it can still take a couple of years to get rid of those creditors, to get them to eventually say, oh, okay, I'll write it off.
Yeah. And what happens with, say, like joint bank accounts, mortgages and property ownership in terms of, those assets, and how
so
does
your
that
joint
work?
bank accounts pass automatically on death to the surviving owners.
Yeah.
So whoever's named on that joint bank account would then take control of it, and taking the death certificate to the bank is sufficient for that to happen, and that passes outside of the estate because it was held jointly between those two people.
Does that take time? Because sometimes we hear of where the bank's frozen that
It shouldn't. It shouldn't take time. All banks
Yeah.
are different and do cause more problems than they need to sometimes. But no, you could die today and the other person could go to the bank tomorrow if they've got the death certificate and have it transferred. It shouldn't be frozen in any way, shape or form because the other person is still alive and still needs to use that account. The only things that should get frozen are anything that's in your sole name, which is then obviously what you need the estate administration process and the grant for. But no, the joint bank account should pass automatically, and the same with anything else joint to a certain extent. So there's lots of things you can't have joint. You can't have joint shares, you can't have joint ISAs, but anything else, particularly financially in the sense of bank accounts and similar, would pass automatically. Joint property is slightly different because, again, it depends on how you own it. So there's two different ways of owning property. One is joint tenants, which means that it does pass by survivorship. So again, it would pass automatically and it would pass outside of your estate. There is a form that you need to do to the land registry to physically sort that out. It's not immediate in that sense. But again, it's not a complicated process. But if you own your property as what we call tenants in common, which some people do where they've got family members on the deeds, or they've got second relationship or marriage and similar, where they've put in different amounts of money, your share is yours to do as you please with, so you can leave your share under your will. So sometimes people in second marriages would leave their share to their children as opposed to their spouse. That's more complicated to sort out, but again, it all falls under the administration process, and that's what you would use your grant for.
Okay, very good.
So we talk about wills. I know we're talking a lot about wills at the minute.
That's fine.
Can people contest a will?
Yeah.
And if they can contest a will, what gives them the right to contest a will?
So anybody can make a claim against an estate if they really wanted to, even a complete stranger. But you have to have solid grounds to do so. So any claim that came in would have to be looked at, but then most, would be thrown out, so to speak, if you wasn't anybody to the deceased or you didn't really have a right to make a claim. The most common ones are children. So children make claims when they're not benefited, or they're not benefited by what they think is enough. So they think, oh, well, I didn't get all of it, I should have got all of it. So they're the most common ones, but you have to go through quite a lengthy process to request the information. Most people get a solicitor to do it for them. You request relevant information in relation to the deceased, the time that they made the will, the questions that they were asked, who made the appointment for them, if anybody was at the appointment with them, if they were capable of making a will, did they understand, etc. And from a point of contesting the will, you've got to have as much information and proof and evidence as you can that those things weren't right, or they weren't complied with. Dad didn't know what he was doing, he didn't understand it, he left me out because he was confused or because my sister forced him to, before it's then taken a bit further and to the next stage. But then most situations, both parties would get a litigation solicitor and then fight it out.
So to kind of combat this then, when somebody is doing a will, how would you encourage people to make sure that these kind of firewalls are there so that you get exactly what you want?
Once we've taken a lot of information and questioned the person onto why they're leaving somebody out or why they don't want somebody to benefit, and taken as much information and background as we can, which we will probably need for the future, we then prepare what's called a statement of reasons in support of your decision, setting out what you've done, why you've done it, how you were at the time that you did it, that you did know and understand what you were doing, that it was your choice and not anybody else's, to protect your position as far as we're able, to say why you obviously left somebody out, because obviously down the line you're not going to be here to tell your story. We have similar information in our file, which we can obviously use down the line to fight a claim if necessary. And then sometimes some people, not necessarily on our advice, but sometimes some people would leave something to somebody. So sometimes people choose to leave a family member a small gift as opposed to nothing, because they think it might, settle the boat rather than rock it.
Yeah.
In that sense. But at the end of the day, it's up to the person that, within reason, they can do whatever they want. And if they really don't want somebody to benefit, then that's fine. There are times when we might question what they're doing, dependent upon age and health and any medical conditions, but then we would look to obviously have that person assessed and get a doctor's report or similar to confirm that they do know and understand what they're doing, and that they are okay at this time to make the will in the manner that they're going to.
Okay.
And then again, that would support down the line when somebody says, oh, my mum didn't know what she was doing because she had dementia.
Yeah.
We can say, well, 3 years ago we got a doctor's report, if necessary, to say she might have had dementia, but she did understand.
Yeah, it's backing up everything, isn't it?
Yeah, so more so now than ever, we do as much as we can on your behalf as the client to make sure that it is what you want, that you do know and understand what you're doing, and that then we've put whatever we need to in place so that if we are questioned down the line. Because obviously if somebody makes a claim against a will, the first person that's questioned is us as the will writer, and then the person as to what they've done and why they've done it.
Yeah. Okay. And this might lead nicely into, I've got another question actually about wills. Obviously there's solicitors out there that do wills, and I guess many years ago, it was just the place you always went for a will, whereas now you've got social media, you've got other ways. What is the benefit of using a local solicitor?
The benefit of using a solicitor to get it done is that you're getting it done in the right manner.
Yeah.
Because when you get your will pack from W.H. Smith's or similar, it's not necessarily written in the way it should be written. Yeah. So when people say, I give all my property to my next door neighbour, for example, to us, that's property, that's house, that's land, that's buildings. To them, it probably means everything because they're classing it as all their property.
Yeah.
But to us it's not, because everybody always has something else after you've pinpointed certain things. So it definitely would get written right. You've definitely got better advice, or some advice if none, because, you know, when, like I say, when you go to WH Smith, you're not getting any advice from them, are you?
No.
And then you've got the opportunity to come back and change it at any point in any way, shape or form, and simply come and ask us the questions to establish whether it needs changing or updating.
Yeah.
Because again, people don't necessarily understand that when somebody's passed away or similar, that affects what they've got in the will. It might not, again, depending on how it's written,
Yeah.
but it can affect it.
Yeah.
And when you're writing it yourself in the manner that you think is the correct way to write it,
Yeah.
doesn't necessarily mean it is.
Yeah, I think it's like a lot of things, isn't it? You know, if there's people out there that are professionals, why would you not really
They're there for a reason,
them?
aren't they?
Yeah, absolutely.
Yeah.
Yeah, okay. In terms of the practicalities after death as well, so registering the death, what's your take on that side as a legal person, you know?
So it's quite easy to do and it's quite straightforward, but it does cause problems, again, with who should do it, how it should be done. Usually it's somebody who was present at the death that should have done it, and usually it's within 5 days of the person dying, but situations have changed recently, the rules have changed recently, and again, when somebody passes away, where they can't automatically issue a death certificate because a doctor can't sign off it. Again, there's slightly different situations with when you get an interim certificate and if it's issued to you or if it should be issued to somebody else.
Okay.
But it's something that has to be done. You can't get away from it. But it all depends on how that person's passed away and who's there at the time.
Mm-hmm. Okay. And let's talk a little bit as well about the deceased home and their possessions and their finances. I mean, that must be an area that you get totally embroiled in at times. And again, the legal take on that side and how that works, and is there any pitfalls in there?
So again, there's rules and regulations in place in relation to what should be done and how it should be done, and it all boils down to who that executor is and who should be doing it. And often we find our biggest problem is it's other people. So they'll say, oh, well, I've been in my mum's house and I've done this and I've done that and I've been to the bank and, I've cleared the fridge out and similar. And it's like, right, okay. It's all well and good if you're the executor because you're able to, and as much as we appreciate, it's mum's house and that's why you've wanted to do it, it doesn't necessarily mean that you should be the person that's doing it. Yeah. And again, dependent upon who somebody's left their estate to can depend on whether you should be that person doing it and whether that's going to have any backlash on you because you went into that house and shouldn't have. So the best thing to do generally in all situations is seek some advice. Yeah. Find out what the situation is. Did the person have a will? If they did, where is it? Who was the executors and who should be doing all of this before you then start to do anything? Yeah. Because a lot of people, they'll have an appointment and they'll come to us and it's always, I've done this, I've done that, I've been here, I've been there. And then we're like the last point of call. Yeah. And it's like, right, well, you shouldn't have done that, you shouldn't have done this, and you shouldn't have been there.
In theory, you should have been the first point of call.
Yeah, and we do try to, like when people come in and they make the wills, we do try to say to them, look, down the line, this is what you should tell your family, this is what they need to know, this is what they need to be doing when the time comes. Yeah. But it doesn't always get passed on, and it doesn't, a lot of people, they just do as they please anyway. Yeah. And they don't like what you tell them. Yeah. If they've done something they shouldn't have done. Yeah.
And I guess there's those that feel like maybe they're helping, don't they? Yeah. Where in that instance.
And sometimes it is. Sometimes it is a help. Yeah. But it still doesn't necessarily mean it should be them that's doing it.
Yeah. So from this I take that we should come and see the solicitors first.
Yeah, even if you just come, take some advice and then go away and do the rest yourself, that's fine. You don't have to instruct us to do any of it if you're appointed. But at least if you know you're appointed and you're okay to be doing those things, if you're questioned by anybody, you're in the right because you've been and you've taken the advice.
Yeah, okay. And the final one from me was really around accessing pensions, insurance and benefits. Again, I think that's another one, isn't it, where, you know, people are very quick to want to try and access those types of areas.
Yeah.
What's your...
Because it's money. Although people say it's not about the money, it always is. And that's at the forefront of everybody's mind. So I need to sort the insurance, I need to sort the bank, I need to, you know, deal with the money side of it. But you don't.
Yeah.
You know, if the money's stuck in the bank, it's not going anywhere. It's stuck in the bank. If the money's with the pension company, again, you're not going to lose it because it's stuck there until you can follow the procedure that they want you to follow.
Yeah.
Pensions all work in a different manner. So it depends on who your pension's with and what their rules are as to how you can get it out and who benefits. Life insurance is same. They all work in a different manner, but most of them will pay out immediately. So as long as you've got the death certificate, you can get that money before you can get anything else. So it does, again, depend on what the situation is, and the best thing to do is take some advice.
Yeah.
And then you can establish what needs dealing with and how it needs dealing with.
Yeah, and I think, like you say, you know, they've all got systems, processes, procedures.
Yep.
It could take weeks or it can take years, like you say.
They're all different, and most of them should want the grant of probate.
Yeah.
Because anything over £5,000, you should really have that document.
Yeah.
And often you find that families have written to all these companies and they've sent the death certificate in because that's what they've asked for, and then they can't get any further. Because they send forms, and the forms say you've got to be signed by an executor. They say we want the grant of probate sending. So then they come to us and say, I can't do any more. And it's like, well, you shouldn't really have done the first bit, but I mean, it's not the end of the world. But then we have to backtrack and start from the beginning in some respects to do all of the same, so that we can get the relevant paperwork sent to us once we've obviously got the grant of probate, to then complete your other documents and send them off afterwards.
Very interesting. Excellent. Okay.
I think that's pretty much it for us today, Laura.
Yeah,
Thank you ever so much for coming in and answering some of the questions.
Yeah.
I'm sure at a later date we'll grill you even more on some more in-depth topics.
Yeah,
but greatly appreciate you coming today.
No
Thank
problem.
you.
Thanks for having me.
That's
You're
it for
welcome.
today. Take care, everyone. Speak to you soon. Thank you for joining us for this episode of Just Talk Funerals.
We really care about what you think. We'd love your feedback on the subjects raised today, or maybe you have a question you would like us to talk about in a future episode. You can contact us by emailing podcast@threadgoldfunerals.com.
If you'd like to know more about what we do and the services we offer, then please head to jasonthreadgoldfuneraldirector.com. Thank you for joining us today, and see you next time.